A lot of you are using dispute letters that you shouldn't be using and you need to stop using in 2023. My name is Michael Wasylik. I'm one of the lawyers at Ricardo and Wasylik here in Florida, and together with my partner Jason Ricardo, I help people just like you overcome debt collection with dignity. And today, I'm going to tell you which letters you need to stop using in 2023 and what you should be doing instead. Number one, any online or electronic dispute form that a debt collector provides to you. There's a reason they make those so easy and so convenient. It's because they're trying to divert you from what actually works. They're trying to bait you into doing something useless. Because when you submit something online or electronically, you can't prove what they got. You can't prove that they did get it. If you're not putting it on paper, if you're not putting it in the mail, you are wasting your time. There's a reason they want you to use them, and it's not because they want you to be more effective when you're filing your dispute. Number two, any dispute letter that you send without getting a certified mail return receipt. You've got to have the green card so you can prove they got it, because if they ignore you and you don't have that green card, you've got no legal recourse and you're out of luck. You've just wasted your time and you're not getting any closer to a solution. Number three, any letter that just rehashes the same argument you made 1, 2, or 3 letters in a row. If you sent that first letter and they ignored you, or it came back verified, then your second letter, third letter, fourth letter that say the same thing over and over and over again, you're not going to get a better result and you're just wasting your time. Number four, any letter that falsely claims that you've had your identity stolen or makes any other false statement in an attempt to dispute your debt. For claims like that, debt collectors are almost always going to want you to provide some kind of proof, and when they ask you for that, your lie is going to be uncovered. And if you are lying when you submit a dispute letter, you may be committing fraud, or even worse, you may be violating federal law in a way that exposes you to civil or criminal liability. It's not a good idea. Don't do it. Number five, any letter that asks for a wet ink signature contract. Wet ink signatures haven't been a thing for decades now. Anytime you've ordered something online or installed a software package or put a new app on your phone, you are signing things electronically. That's the way almost all signatures are done in most commerce nowadays. And if you ask for a wet ink signature, all you're showing the other side is that you don't know what you're talking about, because they know and you know that you don't need to have signed something in order for it to be enforceable against you. So don't ask for a wet ink signature. Number six, any letter that uses overly aggressive language, threatens lawsuits, threatens regulatory action, or any other kind of consequence for the other side. Those don't make you look tough. They don't make you look smart. All they do is make you look like a jerk. And here's why that's a bad idea. When you look like a jerk, you're not being persuasive. The other side isn't impressed with you. They're not afraid of you, and they're not going to be more afraid of you if you threaten them. You might have to go to court to enforce your rights, and that letter is going to pop up, and the judge is going to see it, the jury is going to see it, everyone's going to see it, and if you look like a jerk on paper, then the judge doesn't want to help you, the jury doesn't want to help you. You're digging yourself into a hole and make it harder for you to get the relief that you're asking for. So don't be a jerk when you write your letter. At best, you're going to be embarrassed, and worst, you might talk yourself out of the relief you're looking for in the first place. Number seven, any letter that uses excessive legal citations. Many template letters you find online are going to contain this kind of legal mumbo jumbo that doesn't impress anybody. Anything like a 609 letter or any letter that contains multiple references to federal statutes is going to be guilty of violating this rule. Here's why it's a bad idea. Unless you're a legal professional, and sometimes even if you are, you're very likely not using those citations correctly, especially if you found them in some form letter that you looked up online. Most of those citations are, at best, incorrectly used. And when you use them incorrectly, all you do is undermine your credibility. You show the other side that you don't know what you're talking about. And so instead of having the desired effect, which is to make them afraid of you, you have the opposite effect, which is to make them not respect you. They're more likely to ignore you. They're more likely to try to roll over you because they think you don't know what you're talking about. Even if you are using those citations correctly, it makes you look like you're threatening litigation, and that makes you look like a jerk, which means you're violating the last rule. So don't use a lot of excessive legal citations. I don't when I write letters. You shouldn't do it either. Number eight, and this ties into the last one, any letter you find online that's this long form letter that has 23 categories of documents you're demanding, long, extensive legal diatribes about how the other side is the most evil corporation to walk the planet. Anything you find online that's more than a page, page and a half, it's got lots of legal citations, it's got lots of legal theories, and it's got lots of demands for documents that you may or may not be entitled to. those templates are going to backfire for two reasons. Number one, like we've talked about before, it's going to make you look like you don't know what you're talking about. Because if you ask for things you're not entitled to, if you cite to federal laws you don't know what they mean, if you are saying things that aren't backed up by reality, you're going to undermine your credibility, and the other side is going to respect you less than if you hadn't used those terms in the first place. And there's another very important reason you should never use template letters you find online, and that is this. All the major parties who are receiving these letters keep a database of the letters they receive, and every time they get a new letter, they search that database to see if the text in your letter matches something that they've already gotten. And if it does, they know you're using a template that you found online. And again, they will respect you less because they think you don't know what you're doing if you're using those online templates. Or worse, they think you've hired somebody to do it for you and that person doesn't know what they're doing. So now you've made two mistakes. One, you don't know what you're talking about. And two, you've paid money to somebody else who doesn't know what they're talking about. So if they figure out you're using a template letter, and they will, they're going to have even less respect for you and you're much less likely to get what you want. So now that you know what not to do with your dispute letters, here's what you should do instead. First of all, remember that by definition, a dispute letter must be disputing that specific thing that you're responding to. So the first thing you want to do is include a reference to the thing you've just received. So whether it's a credit report or a debt collection letter, you'll want to say, I'm responding to this letter, to this report that I received on such and such a date. You may even want to include the letter or the portion of the report that you're responding to, because that helps identify who you are and what account you're referencing. If you don't include the letter or the report, you'll want to make sure that your letter, in your own words, gives some brief identifying information about what you're responding to. No more than a sentence or two for this part. Then next, in your dispute letter, in your own words, you should describe the problem. Whether it's that account doesn't belong to me, or that balance is incorrect, or whatever the dispute is, you'll want to state it simply in your own words in a sentence, maybe two. And then the third thing you're going to do is ask for relief. State very clearly in your own words the relief you're asking for. Do you want them to stop collecting? Do you want them to correct their records? Do you want them to remove the item from their records? Whatever it is you're asking for, ask for it there. Now, this part is optional, but you can also request certain other information. For a debt collection dispute letter, you can ask for the name and address of the original creditor. You can also ask for information to so-called validate the debt. I've done other videos on what it means to have a debt validation request. I'll link to those videos in the description below. And there's one more optional thing you can include in your letter. You can limit how and when they're allowed to contact you if they're a debt collector. You can ask them to never call you on the phone. You can ask them to only communicate with you by mail. You can tell them to stop communicating with you at all. Now, if you've asked for information, you can't tell them to completely stop communication, but you can say, stop communicating with me about this debt except for giving me the information that I've asked for in this letter. If a debt collector communicates with you in a way that violates your request, so for example, you say, don't call me on the phone, and they call you on the phone, that's probably a violation of federal law. It's something you could even sue them for, and that violation gives you more leverage to get a better outcome on your debt dispute. And then finally, keep a copy of the letter that you're sending and mail it off certified mail return receipt. Make sure you get the green card, so if you have to take them to court to enforce your rights, you can prove that they got the letter and when they got the letter. Now, if you're writing a debt dispute letter for the first time, you're probably going to want more information about how to do it and what needs to go into it. So I'm going to put a video on the screen now that'll walk you through step by step everything you should include in a debt dispute letter, everything you need to do in order to make sure that you are protecting your rights to the maximum extent possible, and what to do if the other side ignores your letter or fails to respond to your letter. So watch the video I've got on screen now for all that information. Thanks for watching. I'll see you on the next one.